We're now joined by Ms. Karen Escobar. Karen is an assistant U.S. attorney within the U.S. Department of Justice, and she's gained a very good reputation for vigorously prosecuting laser hazard perpetrators. Karen has traveled here from the West Coast. We're very glad that she's been able to join us here today. And this is just another indication of her and the Justice Department's strong commitment to eliminating laser hazard strikes against our pilots. Karen.
Well, thank you. And thank you, ALPA, for having me and getting me out of the office from California. My office is, I'm with the U.S. Attorney's Office in the Eastern District of California. Traditionally, we fall within a very liberal circuit. It's the Ninth Circuit. So that may have some effect on how prosecutors think, very reluctant sometimes to do anything new. But we've had quite a bit of success in our district. We're the biggest district, judicial district that is, not congressional district, although Congressman Lundgren's district falls within our judicial district. But we've had some success. We're the biggest district in California. We extend from Bakersfield up to the Oregon border. And we have been hit with a number of these laser cases over the years. And thanks to Tim's good work setting up some laser strike working groups in our district, there's one in Bakersfield, one in Sacramento, we've been able to coordinate and successfully prosecute many of these perpetrators. The key is to report these laser events. Without your help, without the pilots reporting the incidents, we don't have any prosecutions. I have had referrals, a number of referrals, and there are a number of referrals to our laser strike working groups. We don't have the suspect. There is a reported incident, but we're not able to find a suspect, so there's no prosecution. The key is for you to document, let the air traffic controller know that you've been hit by a laser. If that's not, doesn't result in anything, I know you're not going to follow up with law enforcement, but FBI is the federal entity charged with investigating these crimes. You can always contact the FBI office. There's an FBI office almost everywhere in the country, even in Fresno, which is where my office is actually located. So you need to document. We need to gather evidence of the laser strikes. And the key to that is completing, not only reporting the incident to the air traffic controller, but completing one of these forms, the laser beam exposure questionnaire, which actually we do use as evidence in the prosecution to establish the interference with air safety. And you will find that form. It's on that advisory circular one of the speakers referred to, one of the FAA speakers. On the back, it's in your pamphlet. It's on their website. Complete that form. Send it off to FAA. Cornelius Moore with the FAA is right here. I don't know if he's actually reviews all of them, but there is a repository, and then they can refer it out to law enforcement. So be sure to document the incident and any effect, certainly on your eyes, any injury, whether it be temporary or not, can assist us in a successful prosecution. In California, as one of the speakers mentioned, there is a crime that makes it unlawful to point a laser at an aircraft. The federal law is a little bit more convoluted because currently there is no crime that actually, no federal offense that makes it a crime to point a laser pointer at an aircraft. It would make it a lot easier for us prosecutors to be able to prosecute the actual lasering. Right now, the offense, it's under 18 U.S.C. 32, relates to the interference of the safe operation of an aircraft. The problem for the prosecutors and the courts with that federal crime is the burden of proof. The knowledge element is very difficult, or it's higher than the usual knowledge element that applies to most federal crimes. The knowledge element is a willfulness element. The perpetrator or the suspect has to have we have to be able to establish a willful use of the laser to show an interference with safe operation of aircraft. It's a high burden. So state prosecutions may be warranted in some instances. In California, it's easier just to send it to the DA's office. However, we're all constrained by budget issues, especially in California, and we don't often have the resources at the state level. Even at the federal, we too are often on a continuing resolution in our office. Haven't been furloughed yet, like some of the FAA has on a number of occasions. And in any event, so proof is easier at the state level, but that's no reason not to take it federal. The advantage to going federal is we actually have the hammer. We can send people to federal prison. State, even though the statutory maximum penalty at the state level, at least in California, is 3 years, our maximum is 20. And we actually do send people away. People that have been prosecuted at the state level for lasering aircraft typically get probation. At least that's been my experience. What about you, Tim?
It's about 50-50. We've got jail time for half and some kind of probation for the other half.
The people who go to jail typically have terrible records, criminal history. Often people who are violent offenders, people who have in the past, through their criminal history, have shown reckless disregard for other people. People that I have dealt with have been involved in very interested in explosive devices, have been convicted of various crimes relating to reckless disregard of human life. So those people do go to jail. So federal level, as I was saying, the offense, the only offense that we have currently to prosecute is a general offense, willful interference with safe operation of an aircraft. And that's under 18 U.S.C. 32A5. If more than one person is involved, we can charge a conspiracy. The advantage of federal conspiracy statute is you do not actually have to show the completion of the crime, 32, willful interference with safe operation of aircraft, just an agreement between two people to interfere. You don't have to show the completion of the criminal act. Conspiracy, some people call it the darling of the federal prosecutors. We love conspiracy because it's much easier to prove an agreement to do a criminal act rather than to complete the criminal act. 32A5 is the conspiracy portion of the statute, also the attempt portion of the statute. I have recently charged an individual, again out of Bakersfield. I don't know why we have a high rate of incidents in Bakersfield. And those incidents typically involve law enforcement, the helicopters used by the deputies. In any event, the last one I charged attempt. Again, with an attempt, you don't have to show the completion of the act, just the attempt, the taking of a substantial step to complete the willful interference with safe operation of an aircraft. Be much easier to be able to prosecute all of these people under Congressman Lundgren's bill or the Senate's bill. Anyway, okay, so the advantage to going federal is we have a few tools to play with. We don't have to actually show the completion of the interference by charging attempt or conspiracy, and we have a significant hammer, the 20 years, and a fine of up to $250,000. Since most of the people that we deal with are lowlifes, they never have any money, so the fines never apply, but the prison term is a strong deterrent. Okay, and some of the FAA people today have referred to the fact that they now have a regulatory tool. It's a fine of $11,000 for every single laser incident, which is a hammer, but it wouldn't apply to our pranksters and typical criminals who are involved in these events. But it's a good tool, especially for those juveniles who may have a sugar daddy. Anyway, The $11,000 fine just came into effect just this year, and we're grateful to have that tool as well. Legislative history of the only federal crime that we have now to deal with. Under 18 U.S.C. Section 32, that was A5, the offense of the willful interference with safe operation of an aircraft, was enacted as a result of the Patriot Act. And that was just recently, 2001. Hasn't been in effect very long. And it added the crime that we're concerned with, and just did some renumbering to place the conspiracy and attempt portions of the statute into 32A8. Okay, you've heard from Congressman Lundgren about the attempts to prohibit actually pointing a laser at an aircraft. There has been some background. He went over his efforts. He just introduced it this year. Senator Whitehouse is a friend of yours. He said current federal law does not give prosecutors ready tools to prosecute. And I, as a prosecutor, can say that that is very true. Tim was telling me at a break that there was an assistant U.S. attorney out of Los Angeles who recently went to trial, and she said, that's the last one I'm doing until this bill that Congressman Lundgren has introduced actually passes. Because the intent portion of the current statute, 18 U.S.C. 32, it's difficult. And willfulness has different meanings within different contexts, and so defense attorneys have a lot to play with. And again, then our liberal justices are very reluctant to often err on the side of the defense. Let me just put it that way. So I think Senator Whitehouse is correct in saying that we need to get more specific legislation, and that would serve as a deterrent. And thank you to Congressman Lundgren for being persistent. So it's pending, that the legislation is now pending, waiting President Obama's signature. A few more hurdles, got to get out of that congressional gridlock. Now, the problem with the proposed legislation is that the statutory maximum penalty, the most we could be able to send these people away, is 5 years, which if there's anything that can be done to increase the statutory maximum penalty, or if any of you have any legislative hooks, that would be great if you could suggest, just upping the 5 years, because 5-year penalty is not much of a hammer, especially since the sentencing guidelines also have an effect, and I'll talk to you about those in a minute. You don't have to concern yourself too much as pilots with the sentencing guidelines, but they're also a factor that goes into the calculus, and it all becomes very mathematical in how a judge determines the appropriate sentence. But the sentencing guidelines do play an effect, so the 5-year statutory maximum is not great. Anyway, the language of the proposed legislation is great. So here is the language of the crime that we are dealing with now, the only federal crime that exists for us to now prosecute those who laser an aircraft. As I said, Title 18 of the United States Code, Section 32A5, does make an offense to willfully interfere with the safe operation of an aircraft. And as you see from the reading of the statute, there's language that relates to intent, which in a court of law becomes rather murky. And the willfulness element, as I said, is also not clearly defined. That willfulness, the definition of willfulness varies with the crime. And so the courts get confused. And again, this language, while helpful because it's broad, is also not helpful because it's actually too broad and the intent element's very high. We have to be able to establish with intent to endanger the safety of any person, with the help of a doctor, FAA, has an optical research unit, and we've also used Dr. Nakagawara to show the effects of radiation or a laser on the human eye. That's helpful, but again, we have to be able to show that the defendant, the individual, had that intent, and sometimes that's difficult. So is this with a reckless disregard for the safety of human life. That can be a difficult thing to show. And here's the language that relates to conspiracy or attempt. Very straightforward. At least the language is. So it is a crime to aim a laser at an aircraft. The statute actually says any aircraft in the special aircraft jurisdiction of the United States. And then there's this other language too. Basically, don't be confused. That's all just kind of lots of legal mumbo jumbo for any aircraft. The definition is found in Title 49, and this is what it states, what special aircraft jurisdiction of the United States means. Basically, it is any aircraft. So. If it flies, it's legal, Tim says. So that statute, 18 U.S.C. 32, is going to apply to any laser aircraft, lasering of an aircraft. Okay, so let's just do a case study. This was the first prosecution in our district, and it was mine, the first of many. U.S. versus Dooley and Snow, the aircraft that's pictured is the actual helicopter of the Kern County Sheriff's. Kern County covers Bakersfield that was lasered. It was flying again at 500 feet. The laser was a green laser again. Almost all of these are green. I don't think there has been one that's red. Tracked within 1 mile, hunted down the aircraft, tracked it for a mile. This particular pilot did receive some injury to his eye. He reported, and it lasted a couple of hours, he said it was a gravelly feeling that he felt in his eye, I guess like the sand that the one speaker mentioned. Okay, so the key to this was reaction. The reaction was immediately Baker's, and it was helpful that it was a Kern County Sheriff's helicopter that was lasered because they were able to get a radio for help right away. Bakersfield PD responds. They go, the beauty of the laser is you're able to pinpoint the source. And they did, and they pinpointed the source of the laser to a specific address and location. Bakersfield Police Department goes there, no one's there, no one answers. There is someone there. FBI gets involved, JTTF, that's the Joint Terrorism Task Force, typically responds to these laser incidents, at least in our district. And so they took it from the continued where Bakersfield PD left off. Ultimately, we're able to determine that these were our suspects. Jared James Dooley, there's his background there. And again, he was a meth addict, is a meth addict. Well, I don't know now. He is still probably serving his sentence. So he's probably clean by now. And his girlfriend were the two who were getting their jollies out of lasering the helicopter. Both of them had long criminal histories. The laser that was used was that Radio Shack laser, readily available. If there could be any regulations placed on the sale of these, that would be great. This particular laser only cost $50. It was determined to be a Class 3A, which is legal, lawful to have, but it does not seem there's any regulation on the sale. I go to Lowe's and the spray paint is in a locked vault, and these lasers are, anyone can buy them. Green beam, and it is designed for stargazing. Most of these lasers do say that. If you do an internet search, they're all for a lot of astronomers out there. Anyway, okay, if you go federal, the first thing you do is you get a complaint. It has to be done within 48 hours, or you can proceed by indictment. That means I go to the grand jury. At some point, all federal felonies proceed by indictment. Okay, here's the complaint that we filed in this case, Dooley and Snow. We allege those violations. We got our indictment, went to the grand jury, alleged the same violations. These are the elements. Not too much of a concern for you guys, but the burden is somewhat high. Okay, agreement to interfere with safe operation of an aircraft. The way to establish the interference is by showing that you were injured. I mean, that's the best evidence, or there was a disruption or of aircraft operation. We like to have experts. It helps 12 jurors to agree that there was a crime. And we used Dr. Nakagawara, who's very knowledgeable optometrist with the FAA. Okay, again, I can't emphasize enough the necessity of documenting your laser incident if and when you do get lasered. Use that laser beam questionnaire. The questions that are on it are useful for us, at least from an evidentiary standpoint. If there was an evasive maneuver that you executed, that's very helpful for us as evidence. This question, how long was the exposure? Very helpful to establish willfulness. Did the light seem to track your path? All helps to show a deliberate conduct by the defendant, the actual injury you get. And all that's contained in this laser beam exposure questionnaire. So fill those out. Those are the legal elements. I'm going to whip through them. Here is we like to, in these prosecutions, get an expert in radiation to see what kind of laser was actually used if we do seize a laser. And in this case, we had the Army look at it. Recently, I used the Air Force. They have, and most military has someone in the research of radiation. The Dooley laser was determined to be a Class 3A, and those were the relevant conclusions of the expert with the Army. He's no longer there, so that's why I went to the Air Force. Wes Marshall was very knowledgeable. However, he's retired now and charging, I think, $8,000 to examine the laser. And as you know, the government has no money. But hopefully FBI gets an expert in place to analyze the laser, because it's important to show the strength of the laser to establish the potential negative impact on the human eye. Okay, willfulness, as I said, is a higher burden than the knowledge element of most crimes. And the way to show that willfulness was involved is to show most of the lasers, the laser that was used in this case, the Radio Shack laser, does have a warning on it, and that is very helpful to show deliberate conduct. Okay, these are other ways of showing willfulness. In this particular case, the girlfriend said, "We were taking turns shining the laser around, watching the tracers in the sky." They were just having fun. In this particular case, the two defendants did have a criminal history showing a reckless disregard for safety or human life. Okay, those are the legal elements, more of interest to the lawyers. For attempt, basically attempt means you just have to show a substantial step was taken to commit the crime, to interfere with the safe operation of an aircraft. When you take a case federal, everything is more formal and structured, I would say, in the federal court than in the state court. But you do want to have an impact on the public and on the court, and the impact can be made at the detention hearing, because in this particular case, and most of these laser cases, we've been getting the defendants detained before trial. That does have an impact and a deterrent effect. So we got both of those detained at an early stage, and all of the laser defendants I've had, at least, have been detained pre-trial. And I mentioned the sentencing guidelines. Federal prosecutions generally are driven by the sentencing guidelines, which are not mandatory anymore. The Supreme Court has said they're advisory, but they still play a huge impact on sentencing. And again, it's almost a mathematical formula in determining a sentence for a particular crime. The particular guideline for the offense, for the federal offense, is found at 2A5.2 for any lawyers in here. And that sets these base offense levels. It's almost a grid it is a grid that's used to determine the sentence. And these are the various base offense levels to determine ultimately the sentencing guideline range. If we're able to show the endangerment of the safety of an airport or aircraft or a mass transportation facility or a mass transportation vehicle, the sentencing guideline range, the offense level, goes up dramatically. If we're able to establish that the laser was a dangerous weapon, we can apply that enhancement. The sentence can go up dramatically. And again, if this laser is used in the hand of a terrorist, we can apply another sentencing guideline. The sentence goes up even more. Here's the grid, the sentencing guideline grid I was talking about. It's really a table. The offense level goes up and down, and the criminal history of the defendant goes horizontally. The first base offense level, the base offense level starts there. The ranges are in terms of months. So someone with no criminal history, with no enhancements, is facing at least 27 months under this statute. And it just goes up with all these enhancements. If you show, for instance, an impact on mass transportation, the airport, those are the months that a defendant faces under the sentencing guidelines, which still have a significant weight in federal court. And then a terrorist, in the hands of the terrorist, those are the sentences in terms of months that they face, starting at 10 years if someone lasers as a terrorist. These guys pled. These are their plea agreements. They both pled to attempt. For federal sentencing purposes, the sentence is the same for conspiracy and attempt as it is for actually committing the crime. Because this case was new to our district and maybe to the country, it might have been the first federal prosecution in the U.S., everything was scripted. I prepared a sentencing memorandum, and I wrote in that a 24-month sentence is justified given the catastrophic effects, potentially, and the danger to individuals in the air and on the ground when flights are disrupted. My judge was very receptive to those arguments, and he sentenced duly to 2 years. And it was based on those sentencing guidelines I talked about. The girlfriend, often there's a propensity in federal court, maybe it's in the state court too, to give a lesser sentence to the female. I'm not sure why. But she got 18 months. Might have had something to do with the fact that she was able to get out before trial. She went to a residential drug treatment program and claimed, it was all because of the meth. But she got a little break in her sentence, 18 months. Which is still significant in the federal system because there's no parole, and our people who are sentenced at the federal level actually serve their sentence. So here are a few points of contact for you. Cornelius Moore is here. He's with the FAA, and he is the one that receives those laser beam exposure questionnaires, which are important to us prosecutors for evidence. This is a doctor I was talking to about with FAA who has a wealth of experience in studying the impact of laser on the human eye and has great knowledge. Our local FBI JTTF contact, Marty Willis, who's heading the Laser Strike Working Group in Bakersfield, is here, and he told me to tell you, please call him. If you have questions getting all of the law enforcement officers to work with the pilots, he can give you advice. So contact Marty, and I know Tim his name is up there, so he'd be able to put you in the right direction as well. But if anyone's from California or anywhere in the country, he's glad to talk. And here's my contact information. I am looking for anyone from American Eagle because we had a report of an American Eagle lasered in Fresno just recently, and my agent from the FBI says, I don't know who the pilot is. So I'm sure it's somewhere, but if there's anyone from American Eagle, please snag me. And thank you again for hearing from me, and I love Washington, D.C. I was here, some 20 years ago when I worked as a state prosecutor in Montgomery County. And the guy, I don't know if any of you, I know many of you are from here, but they have a big murder trial. He was my colleague, the guy that's prosecuting the Lululemon murder case. John McCarthy was my colleague back then. And then I went to Main Justice here and then finally headed home to California. But it's a pleasure being here today and meeting some of you. Thank you.